Welcome to the Pearson Show's Personal Injury Postscript.
Hello and welcome back to Pearson Show's Personal Injury Postscript with Chris Schaus. Chris is a Baton Rouge personal injury attorney who has been representing clients across southeastern Louisiana for more than 30 years. He began his career in insurance defense before founding Pierce and Schaus in 1992, where he now focuses on helping accident victims rebuild their lives with clarity, compassion, and strong trial advocacy. I'm Chelsea, and today we're talking about why trial experience matters when choosing Louisiana personal injury lawyer. Welcome back, Chris.
Hey, Chelsea, good to see you again.
You know, these topics are pretty fun for me. I'm learning so much every episode. Let's start with why trial experience matters in personal injury law.
Well, everybody knows the majority of cases settle. That's been the case for a long time, and it's still the case. It's changed some, but it's still the case. What makes cases settle? The facts. The facts make the case settle, and specifically the prospect of an unfavorable outcome at trial. And when I go to an accident scene, when I have a first conversation with a new client, for me, it's automatic. What's in my head is, all right, where are the proof issues? What proof are we lacking, and where am I going to find that, and how am I going to present it? Oftentimes, the question is, where do I find the evidence? Sometimes, how do I present the evidence? They're different questions, different considerations.
A lot of Louisiana injury cases settle, like you said. Why does it still help to have a lawyer who's prepared to go to court?
You know, one of the things that's changed a lot in my 30 or 35 years is the rise of mediation. And so now mediation is an assisted settlement conference using an attorney or a retired judge as a neutral to help the parties reach settlement. And that we resolve a lot of cases that way. It comes up in those mediation conferences. Look, we're stuck at this number. Why won't you go any higher than that? We don't think you can prove that element of your claim. We don't think you can prove the full value of the claim up. And, an experienced trial lawyer says, oh no, it's coming in. Here's the evidentiary considerations. Here's the applicable code of evidence article. Here's how I'm going to get it in. If that's a winning argument, oftentimes the mediation moves on and they say, ooh, he knows that. He's got that handled. We're not going to get him on that one. They play those cards, and somebody who hasn't been in trial a lot may or may not know how to respond to that. It's a pretty common deal. I'm not going higher than $175,000 because I don't think you can prove the other piece of your case. Oh yeah, here's my witness. Here's my evidence. Here's how I'm going to present it. And that's how you move them off a center on those kind of things. Take somebody who's been in the crucible of trial to make those calls.
Earlier you mentioned when I'm at the accident site. That sounds like from the beginning. So how does having trial experience affect the way you prepare a case from the very beginning?
Oh, as I said, it's the facts and the evidence that drive these things, and it's a detailed business. Everybody kind of knows the big picture. The lawyers that are litigating it, the lawyers that are presenting it at trial, know the details. They know the wear marks on that failed part. They know the yaw marks in the pavement on the approach to that bridge. It's those kind of details that break cases open one way or the other. And so, yeah, we want direct evidence, and I want to see it firsthand. Yeah.
How do insurance companies view attorneys who regularly try cases versus those who don't?
Oh, Insurance companies are defended either by in-house counsel or by large outside firms. Uh, Defense lawyers, there's a Louisiana Association of Defense Counsel, just like there is on the plaintiff side. Those guys share information. I used to be on the defense side. We all knew who tried cases. We all knew who never tried cases. Those folks who could and did try cases effectively, we knew our exposure was for judgment value. Those folks who were never going to take that case to trial or do a terrible job if they did so, we knew we didn't have to pay full value on those cases. So you may not want your case to go to trial. Most folks don't. But you probably want a lawyer who tries cases to take your case. It's the specter of trial that gets good settlements.
And how can a lawyer's courtroom experience change the outcome of a settlement negotiation?
You can certainly make the argument it shouldn't be that way. But the fact is, everything matters. Personalities matter. Reputation matters. The experience of your trial counsel matters. You see it in reported cases all the time. Does that lawyer have enough experience and credibility to bring this claim, make the arguments with power and credibility, and such that, hey, he doesn't wind up having to play all of his cards. He doesn't spend 2 weeks in trial. He's able to get to a good resolution. They know if he needs to spend that 2 weeks, he can and will. Those are what drive the things. And you certainly want good trial counsel. If you've got a difficult case, whether you want it to go to trial or not, you want trial counsel.
What courtroom skills does a lawyer develop from actually trying cases in front of a jury?
It's probably number one, being able to think on your feet. There's a lot of pretrial discovery, and the point of that is that nobody gets surprised at trial. Notwithstanding a year or 10 of pretrial discovery, often there are unexpected developments at trial, unexpected testimony, unexpected breaks in the evidentiary presentation. You never know. All kinds of things can happen. Some years ago, maybe 2018, I was trying a week-long jury trial in Baton Rouge, and we were interrupted and lost a day of trial time because there was a fear that the new library was going to collapse and damage the courthouse. Those are unexpected, freaky sorts of developments that can have unexpected effects on, in that case, the defense. They lost a day from their trial time, not from plaintiff's trial time. We got a good result on that trial. I don't know whether it was the building collapse threat that affected it, but you never know what's going to happen. You've got to be super prepared and very alert and able to think on your feet and deal with things as they come up.
Can you share an example of where your trial experience directly helped the client in a Louisiana injury case?
Well, I mentioned earlier that in mediation, we often progress along to a point where, boom, we hit an evidentiary issue and they say, I'm not going any further because I think this issue is going to limit your recovery. And so, to be able to say, I've faced that question before. You might want to look at this trial. It's a reported case. We went up on that issue, and successfully so. I happen to have to return in a bit of research recently to a case that we wound up going to the Supreme Court on. It was an injury case. It was a premises trip and fall. It had been handled by another attorney. He had not been able to get it concluded successfully. And so we had been brought in late on the thing. And we litigated it very vigorously through the trial court, into the Court of Appeal, and ultimately to the Supreme Court. In the Supreme Court, the defendants made an argument that we had anticipated. We did not raise it in direct argument. They raised it in their rebuttal or in their counter argument, and we knew that they misinterpreted the case and were quoting it and citing it improperly. So they make their argument. We presented our case in chief. They made the defense argument. We reserved 5 minutes. They told the Supreme Court justices, we've got exactly a goose case, they call it, and it says we win. And they swing to us and say, well, what about that? What do you say about the goose case? Thank you, Your Honor. We agree it's a goose case, but we believe they're misinterpreting it. This is the case. These are the facts. It's very similar to ours. Here's the key difference. And when you look at it and analyze the precedent, we believe you'll agree. You've got to rule for the plaintiff there. And ultimately they did so. And so it was a good outcome. It was a pretty dramatic moment in front of the Supreme Court. Unfortunately, we were on the right side of it. It went our way that time.
Yeah, it sounds like a movie scene.
It was a good day.
Yeah. What challenges might clients face if they hire a lawyer who has little or no trial experience?
Well, first off, getting any traction at all, as I mentioned. Everything on the front end, it happens in non-litigation. And so if that lawyer doesn't have experience and good knowledge of the complexities, it may be that the insurance company says this, either he doesn't have the facts or he doesn't know what are the relevant facts. But he's not giving us what we need to document the thing for settlement, and doesn't appear that he's ever going to. And so, boom, you're stuck. You can't get it settled because he can't communicate effectively or for whatever reason. And so they can't check off their criteria and make you an offer of any significant level. And so, okay, well, if you can't get the case settled, then I guess we need to file suit. Sometimes the lawyer says, yeah, I'm not going to be your guy. I wanted to settle it, but I'm not going to litigate it for you. You need somebody who says, yeah, if they're not going to do what we need at this point, then we need to get suit filed and get to trial. And typically, when you file suit, boom, you elevate up from a non-litigation adjuster to a litigation adjuster. A lot of times we do that intentionally because the litigation adjuster has better experience, better understanding, and we can make them understand why they need to pay where the frontline claim specialist couldn't get there. But if you can't get it, then hey, you need your lawyer to take the third step and get the thing to trial, whether jury or judge, whether bench trial or jury trial. The defense bar knows whether your lawyer can and will take it the distance, and it makes a real difference in how it resolves and how quickly it resolves.
Finally, how can someone looking for a personal injury lawyer in Louisiana find out whether an attorney has trial experience or not?
That's not as easy as you might think. In the legal community, certainly it's a pretty much known quantity. The lawyers that litigate regularly are a fairly small cadre, a subcomponent of the legal community, and they all know each other. They all see each other at the courthouse every week. The defense bar certainly knows who on the plaintiff's bar tries cases. So it's something you can get from word of mouth. It's something you can get from poking around at the courthouse. You can pull, on the internet now, you can pull reported cases and decisions and so forth. And so you can search for your prospective attorney's litigation record. There's slippage in that, but if they're trying regular cases, you're going to see evidence of it. likewise, if they never go to trial, you'll see that as well.
Wow. Well, thanks so much. And thank you, everybody, for listening to Pierce and Shaw's Personal Injury Postscript. If you've been injured in a car, truck, or motorcycle accident in Louisiana, choosing a lawyer with real trial experience can make a difference, as we just heard. Visit pierceandshouse.com to connect with Chris and his team. And don't forget to leave a review, and share this episode with someone who might need it. Thanks again.
Thanks, Chelsea. Bye-bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.